Thanks, Jay, everyone, and Medill for joining us for our first webinar today regarding coverage of the McGirt V, Oklahoma, U.S. Supreme Court decision. I'm Sterling Cosper, Muscogee Creek citizen and OK SPJ interim president. I am also a program manager for the Native American Journalists Association, and I'm very pleased to host this astounding lineup we have today for both sessions to help us better understand this critical and historical case. As mentioned in our communications for these events, I think a key word for this discussion may be context when it comes to conducting coverage of this case. There's been quite a bit of exploration regarding concerns that have been raised about the reaffirmation of the Muskogee Creek Nation's reservation and its impact on jurisdiction. So I'm joined today by our guests who will share their expertise on the case and help provide context regarding its impact. I am humbled and pleased to introduce our panelists: Muscogee Creek citizen Jonodev Chaudhuri, attorney at Quarles and Brady and ambassador for the Muscogee Creek Nation, and Stephen Greetham, senior counsel at Chickasaw Nation. I cannot express enough gratitude to you both for joining us today. I'm also very happy to be joined today by my colleagues and friends from my former employer, Muskogee Media, who have helped us coordinate and conduct these sessions today. This includes Jared Moore, who is handling production, and our moderator, reporter Angel Ellis. Just to note, audience questions may be submitted using the Q&A feature. And from there, I will hand it over to you, Angel.
Thanks, guys. I appreciate everyone coming together so much. It's one of the most important topics, I think, going on in Indian country, and it's one of the most covered topics I'm seeing in headlines recently. And so one of the elements of reporting on the McGirt case, especially as we have entered this phase where we are seeing large investments being made by tribes in policing and administering justice in Indian country, is really closely tied in historical context. It's safe to say that that's probably the least touched topic that I've seen recently in coverage, because I know a lot of us journalists are out there and we're just trying to get the facts out as concisely as possible. But I really wanted to take the opportunity to provide some education on that historical context and allow journalists some insights into where that leaves us today. And I think Jonodev does a great job in providing that historical context. And can you just kind of walk us through the most kind of concise way to how we got to the McGirt Supreme Court decision? I know there's nothing concise about 100 years of history, but can you kind of touch on that a little bit for us?
Sure. And thank you, Angel, and thank you, Sterling. Just deepest appreciation to the Society for putting this panel together and providing the opportunity to discuss these important issues. Absolutely. Truth-telling and reporting are, in theory, one and the same, and you can't tell truth without understanding context. And that's very important in regards to the McGirt decision, because the McGirt decision that was issued in July was just the latest chapter in a story that extends, frankly, beyond the earliest days of the United States. So it's important to understand that context as we talk about the decision. Let me just start from the beginning very, very briefly. The Muskogee Creek Nation, as we know, was originally centered in Alabama, Georgia, and northern Florida. And we engaged with European nations long before the formation of the United States. Our role in the formation of the United States was critical because alliances with tribal nations were critical to the balance of power as European nations sought to colonize the what would become known as the United States. That history led to all sorts of very complicated dynamics leading up to, through the Revolutionary War and then in the early days after the war. Shortly after the war, the U.S. tried to solidify its constitutional form of government, and in doing so, ratified the U.S. Constitution as we know it today. In 1789, the U.S. ratified the modern-day U.S. Constitution. At that time, the United States, this newly formed republic, desperately needed legitimacy on the international stage. It needed to show that it was truly a sovereign nation. And what does a sovereign nation do? It treats and engages in diplomatic relations with other sovereign nations. So treaty making with tribal nations was critical to the legitimacy of the United States on the world stage. I'm very proud to say the Muskogee Creek Nation was the first nation that helped give the United States that legitimacy after the formation of the modern day Constitution. In 1790, our nation entered into the Treaty of New York, which defined the southern boundaries of the United States. And although in that treaty, there was a promise made by the United States to forevermore, relinquish any adversarial positions. That promise was ultimately broken. Since 1790, the Muscogee Creek Nation has entered into a long chain of treaties with the United States, each of which included significant cessions of land and in return for certain promises made. And each time, in almost every case, those treaties were unfortunately clearly broken. And they were broken in a manner that always resulted in a loss of land, but also further pressure being placed on the Muscogee Creek Nation to give up more land. So you see this driving force stemming from this constant desire to acquire Creek Nation resources, Creek Nation lands, and in many cases, Creek Nation labor, driving policy in the United States. So throughout this series of treaties, we get to the 1866 treaty that's in question in McGirt. And I posted an article that, perfect timing, just came out this morning, that talks about the interplay between false narratives and bad policy. And that article lays out the history of the Removal Act and the false narratives that went into play to purportedly justify the Removal Act. It goes into the false narratives that supported the Curtis Act, which allotted our lands. It touches on the false narratives that have driven much of federal Indian policy that has negatively impacted our nation. That brings us to the lead up to the Murphy and McGirt decisions. And we could spend all hour talking about the torturous procedural history of those cases. But long story short, the cases were continually pushed back because of, as we know now, after the fact, of an apparent deadlock on the court. With the arrival of Justice Gorsuch, who's truly a heavyweight in the Indian law community and a Western appellate judge before joining the court had guidance and understanding of underlying Indian law principles that it never had before. That made the difference. In a 5-4 decision issued July 9th, the U.S. Supreme Court, in a beautifully written opinion issued by Justice Gorsuch, simply applied the law. And it applied the law despite the prevalence of numerous false narratives in the lead up to the case. And in applying the law, Justice Gorsuch talked about this history specifically as it relates to the 1866 treaty, but also the history of these broken promises of the United States, and simply said, at the end of the Trail of Tears, lied to promise. That was important. The actual application of the law in the case wasn't significant in itself. Justice Gorsuch applied, frankly, a textualist approach to the existing body of law. There was an existing body of law called the Solemn versus Bartlett line of cases. I think everybody's familiar with it, that simply said that unless Congress shows its face to the world, and I'm summarizing, but unless Congress shows its face to the world in disestablishing or diminishing a reservation, that reservation's boundaries remain in full force and effect. And the court basically looked at the history that applied to Creek Nation, both in terms of federal actions as well as state actions, including the history of allotment, as well as the history of statehood, and various other statutes, as well as state actions that the state was using to try to argue that collectively amounted to a disestablishment of our reservation. And what the court did was incredible, not because of its legal analysis, but because of its intellectual honesty in blasting through all the, as some would term, malarkey that's out there, the false narratives that are out there, to show that despite these, frankly, unlawful attempts by the state to exert jurisdiction on Creek Nation lands, and despite the efforts of some to cast this narrative of disestablishment, the court found no disestablishment. Furthermore, the court didn't buy some of the sky is falling narratives that were presented in the briefings of the case. Let me just briefly run through those. In the lead up to the case, the state of Oklahoma, and unfortunately with support of the United States in a friendly brief, an amicus brief, basically pointed to budgetary issues that would be caused by a truthful ruling in the matter, strains on tribal capacity, strains on U.S. attorneys' capacity to do justice on our lands. They created, without any justification, a narrative that criminals would run rampant, that chaos would reign supreme. And those were arguments that we've seen before. We've seen it in Oklahoma before, when there was a foundational appellate court case in the late 70s, the Little Chief case that established that tribal nations did have the authority to have tribal courts. We saw the same malarkey pushed around, saying that there would be chaos running rampant. That never happened. What did happen is the Indian law community bounded together in this newly affirmed right to create a tribal justice system in the western part of Oklahoma, and built a tribal justice system in many of the western tribes that would have been already healthy and strong had the state and the federal government supported capacity building all along. So we've seen those false narratives rear their head in Oklahoma, and that's certainly what happened in the briefings. But beyond the state of Oklahoma amicus briefs, you had industry writing briefs, and there was an amalgamation of oil and gas and agricultural interests who basically said business will flee eastern Oklahoma if the court upholds its precedents. So please, court, try to find a way to craft some judicial justification, regardless of whatever mental or legal gymnastics it takes, to not recognize that the treaties have never been disestablished. And for that, they again laid forth all sorts of unjustified claims about business running rampant. So it was a double-barreled approach to claim on one end, criminals will run loose, and on the other side, that businesses will flee. The court didn't buy any of that. And thankfully, they had ammunition not to buy any of that. And there was an amicus brief filed by the National Indigenous Women's Resource Center that showed that disestablishing our reservation would make women less safe and would actually be a deadly blow to public safety. It talked about the trajectory of empowering tribal nations to go after bad guys on the ground, and how that shouldn't be reversed through judicial disestablishment. Then you had numerous U.S. attorneys filing amicus briefs in the case, calling into question and completely dismantling the budgetary arguments that were made by the state of Oklahoma, as well as this narrative of criminals running loose. The court did.
Can I kind of like pop in here just for a second? Because one of the things that really plays out in my mind as we were following McGirt through the Supreme Court, and this is a question I'd like to kind of pitch to both of you at this point. How rare is it for Indian country that the context and actual text of the law is followed regardless of the difficulties or these different narratives that were being pitched in argument. You know, how rare is that it actually plays out that way? That seems to be something I think a lot of people missed.
Absolutely. Stephen?
Yeah, if I may, one, I want to piggyback on Jonathan's comments about kind of the mythologies that affect, and this relates as well to your question, Angel. In the context of this case, one of the most pernicious myths that I think has affected perception of the case and some reporting, but I think by and large the reporting has actually been pretty good, is this repetition of, oh my Lord, the reservations are still there. No one thought the boundaries were still there. No one thought that. That is a non-tribal perspective. You look at each of the constitutions of these tribes, they start with a recitation of their treaties and their boundaries. You look at the programs and services that these tribes provide. They reach throughout their areas. So myth number one, this was a great shock. No, it's not. From the tribe's perspective, we've been operating within these boundaries and based on the presumption of our authorities since the state came into being. The issue that makes it more controversial is the Major Crimes Act. And an important contextual point on the Major Crimes Act. The Major Crimes Act was not a statute that was enacted to help tribes. The Major Crimes Act was a statute that was enacted in the late 1800s at a time when the federal government was battling with the states over who was going to have primary jurisdiction in these vague areas called Indian country. By the Supreme Court decision, U.S. v. Kagama, that affirmed the enactment of the Major Crimes Act as a legitimate exercise of constitutional power, has a very interesting discussion if you read it for the context that we're talking about here. The only two sovereignties they cared about were the state and the federal government. They didn't care about the tribes. They weren't part of the analysis at that time. And that's the context that the tribes wrestle with day in and day out, that there's this constant arm wrestling between state and federal, and then the tribes are treated as a bystander, as they were in this case. This was a case between a criminal defendant and the state of Oklahoma. The tribes that participated in this, starting with Muskogee Creek and then each of the 5 tribes and then other tribes across the country, were bystanders as amicus in this proceeding. And that's how these issues play out, and it's a challenge. To your question, Angel, about the kind of how shocking is it? Jonodev touched on this with Justice Gorsuch's arrival on the court. The phrase that jumped into my brain back in 2017 when the 10th Circuit decided the Murphy case was intellectual honesty. One of the biggest challenges tribal advocates have had is that law is law, yeah, but when tribes are involved, things are different. And one of the reasons for that is, tribal advocates will bring up terms like colonialism, and it can sound radical or it can sound like you're coming from one end of the spectrum. But that's what federal Indian law is. Federal Indian law implements a set of pre-constitutional rules and is trying to normalize them within our federal constitutional set of state and federal jurisdictions. So when, starting in the 1980s, really 70s, but really getting steam in the 80s, the Rehnquist Court kind of embraced that more colonial view of Indian law. And the court embraced its policy-making powers as opposed to its purely adjudicating powers. So rather than looking at the law as it is, the court determined how do they perpetuate the colonial mission of essentially terminating the tribes. So since the 80s, the Supreme Court has been a scary place to go as a tribal advocate. The level of predictability you can apply to how Indian law rules will control in a case, you always have to factor in the politics of it as well. So when Justice Gorsuch applied, which I referred to, that textualist approach, that is fundamental to why McGirt is important. He basically said, look, treaties are laws. Congress acted numerous times with respect to the Muscogee Creek and other tribes. We, the court, have to follow Congress's lead on this. And he strictly hewed to the court's prior tests and to the language of those laws. And when you do that, you get results like McGirt. And that, as a tribal advocate, is remarkably refreshing. And I think when looking at McGirt, there's McGirt's implications for Muskogee Creek. There's McGirt's implications for the 5 tribes generally who share a consistent legal history. And there's implications that McGirt has for Indian country generally. I think if you look at it from Indian country generally, it restores a justification for some faith that law is going to matter when it comes to a fight between a tribe and another sovereign. And that's critical.
I have another kind of like, that's a segue for me into the ethical obligations of reporting truth and how we hold those in power accountable and to give voice to the voiceless. I'm a citizen of the Muskogee Nation. Jonodev is. We can kind of all recall that day when we heard this opinion, but the celebrating or the feeling that a lot of citizens felt when it came to having that affirmation of what we've always known. And I think Stephen did a great job of mentioning that some of our programs are just clustered around this jurisdiction, and that's so much a part of what we do. And in service wise, if you live within these boundaries, and you are eligible for help in this way. Can you talk to some extent about that to help people understand the inner workings of that, John? Because I don't think a lot of journalists from the outside looking in really kind of grasped the concept that we've always operated under that standard, no matter what language we use to describe the jurisdiction. It's always been there. Kind of how does the tribe feel about that? You can speak for that.
Absolutely. And I forgot to mention how much of an honor it is, in addition to being with you, Angel, and Sterling on this, to be with Stephen, and deep respect for the work that he does. I agree with everything he just said, with the possible exception of the coverage to date being good. I think the coverage to date has been mixed at best.
Mostly good.
Yeah. It has been mixed. And I do think there's an ethical obligation on the part of journalists to not engage in or not perpetuate echo chambers. And the false narratives that I mentioned before continued after the decision was issued. So there's an echo chamber that is created and around this notion of chaos that we have to look within a historical context of why it's there. And why it's there, narrative creation has always driven policy. False narratives have driven bad policy. True narratives have driven good policy. So I think there is an ethical obligation on the part of journalists to dig in and really look at what the truth is. A good example of this was in the Atlantic. Rebecca Nagel, in the lead up to the case, just completely destroyed the state's arguments about thousands of prisoners running in the streets. And how'd she do it? She did it by systemic, detailed data analysis. And she did a sampling of all the records in Oklahoma and found that it was a handful of folks who would simply be subject to another jurisdiction's authority rather than running on around on the street. And the answer to going after those folks was intergovernmental collaboration. So when you hear these inflammatory narratives, whether it is, and before the case, people were saying half of Eastern Oklahoma was going to go back to the Indians, scaring people, recognizing that the vast majority of people in Eastern Oklahoma and throughout Oklahoma are not Native American. Something like that's inflammatory. The counter to that is the truth. Wait a second, not 1 inch of land changed hands, and what we're talking about is jurisdictional power to go after certain crimes. And what crimes are we talking about? Crimes committed by Indians. And what is the answer after McGirt? The answer is, before McGirt, you had one authority, the state of Oklahoma, that frankly had a checkered record about going after these crimes. And after McGirt, you have two superpowers. In our case, the Muscogee Creek Nation, who, as I pointed out before, was one of the foundational tribal nations on this land that has always played a central role in this in this country's history. And on the other hand, you have the United States having concurrent jurisdiction and the ability to share resources and collaborate and coordinate to go after bad guys. So in a very real sense, after the decision Bad guys were less safe, and Oklahomans were more safe from a legal standpoint than they were ever before. Now, all that's left after that is implementation. And Creek Nation has invested heavily in implementing its authority and collaborating with its jurisdictional partners. It's created, and Chief Hill's created the Reservation Protection Commission. Other tribes have done something similar. And we're engaged in the day-to-day work with state, local, county, and federal partners to go after bad guys together, to make people safer together, and explore opportunities to incentivize business in Indian country. Tribal nations were the first traders on this continent. Tribal nations were the first entrepreneurs. Creek Nation, just like so many nations, is open for business. So again, this narrative that business is going to flee is malarkey. And I believe journalists do have an ethical obligation to look underneath the echo chamber, recognize why these false narratives get perpetuated, and start looking at the history. On the court side, our nation's court system far predates the state of Oklahoma, but frankly predated Georgia and Alabama. That's the root of our court system. Our trade philosophies predate anything that comes from, the founding farmers. We have a lot to add to the conversation of economic development. We have a lot to add in the conversation of public safety. The answer is collaboration rather than driving false narratives to justify bad policy, whether it's bad legislation or bad actions from the state. I would be very thankful if leaders use the bully pulpit of their offices to encourage county sheriffs, county DA's office to work collaboratively. By and large, most of them have. We have ongoing conversations with the governor, with the attorney general, with the congressional delegation, and with the US AG. But we can't do it alone. The local officers need to do their part to ensure orderly transfer of cases, orderly investigation. If another nation wants any tribe-specific legislation that doesn't impact anybody else, we support that. If another nation wants to work with us to build a framework that keeps us all healthier and safer, we support that. But what we don't want is false narratives driving legislation that, as bad policy always does, seems innocuous on its surface, seems an answer to a manufactured problem, and ends up hurting our ability to build capacity down the road. To last point on that, for all the reasons I discussed before, we are convinced that if people understand the opportunities, not just to Native Americans, but to regular Oklahomans, to flourish together based on this clarity that has been brought by the Supreme Court, all Oklahomans, whether they're tribal citizens or not, will embrace this decision, just as the international community has, and will call people on any false narratives that they try to create. Huge opportunity in terms of economic development, huge opportunities in terms of safety of women, huge opportunities in terms of public safety. So journalists do have an opportunity to correct false narratives, look underneath the malarkey, talk to the tribes, and really learn about our plans to build a better future together. McGirt is an opportunity to flourish, not a problem to be solved. That problem narrative is purposely playing into the hands of folks who would otherwise want to push bad policy.
I have a few questions to elaborate on, but I'll let Stephen, I think you had something to add here.
Yeah, well, on specific examples that I think are worth meriting are this notion of business will flee. Milo's iced tea is opening a new plant out in Owasso. I forget the name of the company, but there's a paper pulp company that they're going to have 200 employees. They're opening out somewhere within Cherokee Nation, and they're working with Muskogee Creek and Cherokee Nation to find the high-tech employees they need to operate that facility. This is all happening post McGirt. Flip side. So when folks ask for specifics, it's not the scare tactic, sky is falling, tends not to have facts behind it. One case that got a lot of attention was the serial rapist that was released. First, the district attorney out in city of Muskogee or county dismissed the charges on his own. And then the U.S. attorney was blocked by the federal statute of limitations. And there was quite a bit of, oh my Lord, see, it's coming true now. McGirt is leading to rapists being set free. That case, if you really peel it back, and this is something a reporter could look at, those rapes were committed in the 90s. That was more a function of Oklahoma's failure to do what it's supposed to do with rape kits and to bring timely prosecution than with McGirt. But opportunities like that for a false narrative come in. The one cautionary point, I agree fully with what Jonadev's saying about this problem narrative. McGirt's not a problem, but it does raise challenges. And we have to figure out a way to work through the shift in understandings of how jurisdictions work. And that's going to take a lot of collaboration, a lot of work. And that requires kind of hardcore policy analysis. One of the things that we get lots of inquiries from reporters all the time, and we've been shying away. And it's hard to do that because you want to speak on it, but we're trying to roll up our sleeves and figure out what McGirt means in terms of programs and services, investments, hiring, so on and so forth. We can't count on the federal trustee to always come through with the monies that are needed within Indian country. You just can't. So by operation of federal law, each of the 5 tribes now are in the process of having their reservations affirmed. We now have this law enforcement jurisdiction kind of coast to coast within our treaty territories. That has an impact on tribal programs and services. Our citizens are concerned about that. We're going to have to come up with the resources to address that. So there are challenges. The challenges are different from problems. And the solution to it is going to be collaboration, communication, and intergovernmental partnership.
Wonderful. So I'm going to kind of switch gears just a little bit and ask you both in turn. I'll let Jonodev take this question first. One of the things with truthful reporting is documentation. I'm glad Stephen brought up the serial rapist that story. We watched that play out. I think I've spoke on it on different panels before on how the reporting of this is one of the most intense kinds of reporting as a journalist can do. There are multiple layers to this, and sometimes that determines what kind of form of reporting we actually can do if we're going to do it correctly. In my opinion, there's not much about McGirt, if you're ever going to even mention the word, that you can do short form, because even in that rape case, you have the federal level, the state level, the tribal level. And then, by the way, let's think about our stakeholders who are consuming this news, because that particular story did kick off one of the most reading the comments associated with that story was kind of terrifying as an Indigenous citizen, to be honest. It was very heated and it was very, contentious. So what can journalists do to dig into these topics? And it's, I think, a little bit easier if you're covering a justice beat because there's court filings. But when we talk about documentation, if a news story says XYZ happened because of McGirt, can you speak to some of the type of documentations that journalists should be referencing?
Yes, absolutely. First and foremost, I know the industry's changed. Journalism has changed. Print industry is the print journalism industry's changed. And so given the drive for advertising support, it's hard to lay off the high heat in baseball terms, but sometimes it's good to lay off the high heat. And again, not play into these echo chambers, because a lot of these echo chambers, as I said before, are purposeful. One echo chamber is that everything related to transition issues is a McGirt issue. Okay. First of all, it's not a McGirt issue. The laws that apply to reservations are well known. As somebody who's, long before getting into pure policy, which I'm in as ambassador and my previous role as NIGC, National Indian Gaming Commission chairman, I was in a policy role. But before that, I practiced for the better part of 2 decades in the private arena. With the backdrop of history, but also geographical understanding of Indian law, that there's nothing unprecedented or mysterious about laws that exist on a reservation. There are reservations throughout the United States, and yes, the law is complicated, but it's not unknown. And as long as people take a step and just understand their law and their history, they'll know that there's nothing unique about reservation status. And there are plenty of blueprints for collaboration and coordination within other frameworks that we can just simply learn from. In fact, we had a proposal from our state's attorney general who said, well, we just want the need to compact. Well, anybody that's practicing Indian law knows that that authority already exists throughout every aspect of the civil arena and throughout almost every aspect, but the tiniest aspect dealing with specific subject matter jurisdiction in the criminal arena. And even within that tiny, tiny aspect, there's already existing law. It's got a bad name. People don't like to hear it, but it's called Public Law 280 that allows tribes who want to surrender subject matter jurisdiction for the purposes of compacting or for the purposes of concurrent jurisdiction to have an election and request that authority be given to the state anyway. So there are false narratives around, oh, we need legislation to be able to compact. Don't buy into the echo chambers. Look, talk to folks who understand the law. Talk to folks who have practiced for 20, 30, 40, 50 years. Talk to folks who have practiced Indian law outside of Oklahoma. And you understand the economic opportunities that are available, not just to natives, but non-natives alike. Similarly, not everything's a McGirt issue. As we try to figure out how best to enter into intergovernmental agreements to arrest and detain, and questions come up around things like who's an Indian, who's not an Indian. These are good questions to raise. They're complicated questions, but they're not McGirt questions. I wasn't alive when Brown versus Board of Education came out, but there were people who claimed that chaos would reign supreme if separate but equal was shot down. Fortunately, the United States Supreme Court didn't buy into that malarkey and did the right thing and issued the ruling in Brown versus Board of Education. Was there widespread transition? Were there widespread transition issues that followed in the wake of that historic decision? You better believe there were. But those weren't Brown versus Board of Education problems. Those were transition issues where people are rightfully moving from a broken system to a system of opportunity and figuring out how to work together to build a better future within that system. So as journalists look at these, poster children there that the folks who want to drive bad narratives will always point to say, oh, look, chaos is reigning supreme. Just know where that's coming from. Look at it in a historical sense and know that bad narratives have always driven bad policy. Finally, the last bad narrative that I want to point out, and I certainly respect our sister nations within the 5 tribes, but this is a case that extends well beyond the 5 tribes. There are certain similarities in the treaties among the 5 tribes, and without a doubt, I'm convinced that the 5 tribes will all have and likely all have their reservations affirmed similar to ours in one way or the other soon. And that's already happening. You see the reservations being affirmed in the courts left and right. But you know what? There are other tribes in Oklahoma and throughout Indian country who have tried to make this point as well, that our reservations have never been disestablished. That's not a scary point, by the way, for non-Indian America. That's, again, an opportunity for folks in other states to recognize that this is an opportunity. But this isn't just, one problem I've always had is that for somewhere along the way, this got framed as a 5 tribes case, which absolutely the 5 tribes are directly impacted, but Creek Nation is first and foremost the only nation whose lands were involved in the case. And if you look beyond that, numerous other tribal nations in Oklahoma and elsewhere are impacted. So as journalists look at this, I just ask them not to buy into the echo chamber.
Stephen?
Two points I want to make. One, I agree with about 80% of what Jonodev said. There are two friction points between and among the tribes, and this is always kind of an interesting part of these stories. Anytime you're dealing with some type of non-majority group, there's this presumption of kind of a monolith. And in Indian country is no different with that. Each of the tribal governments that are touched upon by McGirt or anything in Indian law is its own sovereign, and it has its own constituents. It has its own policy objectives and needs and how it sees itself in the world. So each of those nations wrestles with these issues. One, just briefly, I don't know who's arguing that this is only a 5 tribes case. I don't know who's arguing that. From the 5 tribes collaborated throughout the litigation on this case for years, back to Murphy. We collaborated with Muskogee Creek, and Muskogee Creek welcomed our help in drafting amicus briefs. I organized one of those amicus briefs. The reason why there's a 5 tribes lens on it isn't because of McGirt, but it's because of the historic relationship between and among these 5 tribes. We have a legal history that is unique in Indian country, and what happens to one of us tends to affect the rest of us. And we're seeing that happen right now. So it's not meant to be exclusive. But with the first round of implications that come down from McGirt, we're right there on the front line. My understanding is Miami and Quapaw, I believe, also now have rulings about their reservation status. That's going to happen. Law doesn't exist in a vacuum. You have a rule and you have facts. McGirt, as far as the statement of the rule, isn't new. Why this is a 5 tribes case, first and foremost, is because the facts of the 5 tribes have a certain level of commonality. Every tribe benefits from McGirt, however. More substantively, I strongly disagree that the notion that Public Law 280 as an option just is something with a bad name. That's a more detailed policy disagreement. I don't know if that's within the scope of what we're talking about here today. But what I'd suggest to kind of use Jonodev's phrase, don't buy into the echo chamber that that's a false narrative. For example, at Chickasaw Nation, Public Law 280 is a terminationist era statute. Even Jonodev used the term, if a tribe wants to surrender its jurisdiction, that's what Public Law 280 helps you do. We have no interest in doing that. Compacting is the most successful mechanism that we have used. When you've got an intergovernmental conflict, you basically got 3 choices. You litigate, you get Congress to change the rules through legislation, or you compact. Subject matter jurisdiction is not just a tiny little issue. It's fundamental. Indian Child Welfare Act. Indian Child Welfare Act has a provision in there that says, Section 1919, that Indian Child Welfare Act sets up a set of rules for federal jurisdiction. The tribes do not have the power to change rules established by Congress unless Congress says we do. In that provision, it says we're allowed to compact on it. All 5 of the tribes did, each for their own reasons, but we figured out a way to work with the state on a concurrent jurisdiction basis. We can't do that when it comes to subject matter criminal jurisdiction. Some tribes might not care. Some tribes might think Public Law 280 is an appropriate tool. I know at Chickasaw Nation, we're not looking for Public Law 280. We're not looking for a terminationist era statute. We're not looking for the problems that we can have a whole graduate level seminar on the problems with Public Law 280. We think that there could be value in a new path forward. And let me lay this out. If for Chickasaw Nation, we're not particularly interested in establishing redundant programs to what the state has. Our mission is to enhance the overall quality of lives of Chickasaw citizens. That involves public safety, effective law enforcement for everybody. But also, our major investments are in healthcare, mental health, physical health, addiction interventions. We would rather focus our efforts on criminal justice reform, where we're intervening. And if there's a Chickasaw who's caught up in the criminal as a defendant, we'd like to help, if we can, intervene and help them get their life back on track. There's Chickasaw families that are victimized by crime. We want to be able to use our resources to inject ourselves in to provide the services to those families. And rather than surrender jurisdiction to the state, we want a true partnership where we retain expressly our jurisdiction within the criminal justice system and are working in partnership with the state to improve the quality of law enforcement for everyone within our territory. That we see as a path forward. We don't think current law fully empowers that. We think there could be some value in that. Are we calling for legislation? No. Do we think there's something to explore? Yes. Totally agree with Jonodev. Civil side of the equation, we do that every day of the week. We have hundreds of compacts here in the state of Oklahoma. There's nothing on the civil side of the spectrum that Congress ties our hands that we can't deal with through compact. So that's a red herring as far as, and you hear a lot of folks saying the sky is falling on the civil side. It's really a red herring. We'll work that stuff through like we have. Last comment, and I apologize. This is about relationships. We would be in a heck of a different position today if we weren't emerging from 18 months of foolish conflict over the gaming compact. The approach that the current state administration has taken to tribes is toxic, and that's unfortunate. That's behind us now. We're all adults. We need to turn the page and restore a level of collaboration and based on government to government respect between the state and the tribes. And we kind of wish we hadn't just gone through the gaming fight, because I think we'd be in a very different position today to get more effective partnerships off the ground. But we are.
So I have just a few more questions before we start winding down and try to get to some of our audience questions, because they have some great ones. But I do want to kind of take this opportunity to point out that if you're a journalist covering these topics in Indian country right now, whether or not your media outlet is tied to a tribe or not, it's apparent that there are some very subtle nuances that exist even within and between the different tribes. And if we're not even diving into that layer as well, then we're also not doing this topic any justice, and we're not doing comprehensive reporting. It's a very, very intensive amount of work, but to get it done on deadline is sometimes like, you're going a little bit crazy, but it has to be that way because we have to minimize harm in our reporting. And I want to really touch base on that for a minute, because when we look at minimizing harm, it's obvious in the justice system, and those of us who cover justice beats, you do certain things and you protect victims and you do things like that. But we also have this other scope of pandering to lurid curiosity and throwing up maps that say half of the state is falling off of the planet and things like that, that can really impact the public perception and how these communities navigate their world. I've not experienced in my lifetime some of the things that my parents had to experience as Native citizens, but I'm starting to, and my children are starting to. And I think that is directly related to the type of coverage we're seeing in Indian country right now, and the type of coverage we see the Native tribes being left out of. Can you kind of speak to that a little bit, each in turn, however you like, but briefly? And I have like 3 questions I need to pop up here for you guys.
Yeah, and I could just, my sympathies to the industry, because the business model has changed, and clickbait gets more clicks. That's the definition of clickbait. And so it's tough, and I think that touches on broader industry changes that I think go beyond the McGirt decision. But I do think there's time and there are resources available within every tribal nation to do the legwork. I mean, almost every tribal nation has a wonderful public outreach office. Our press secretary, Jason Salzman's, is as good as a guy as there is in the business. I encourage direct relationships with every tribal nation's public affairs office, and before clicking on clickbait, use those resources. But beyond that, if I may, I just want to address a couple of things. I'm very excited, again, honored to be on the panel with Stephen. It sounds like there's an agreement that nobody has argued that this is a 5 tribes case, and that that is true, and that's true. As we see these other cases come out, Indian country is largely unified, that no legislation in any way diminishing the historic sovereignty, treaty rights, and jurisdiction that was affirmed in the McGirt decision should be considered. And on August 13th, a powerful letter was issued by the National Congress of American Indians, the Association on American Indian Affairs, the oldest national advocacy Indian organization in the country, National Center for American Indian Economic Development. We talked about the business fleeing narrative, as well as all the major regional organizations in the country, whether it's the Midwest, Northwest, Southeast, Northeast, Arizona, on and on. And they universally said no legislation diminishing this historic win should be considered. Now, for myself and for my leadership at Creek Nation, we support any nation's sovereign authority to seek tribe-specific solutions. But again, to this larger point about don't call things that aren't McGirt issues, as we support other tribal nations to explore solutions, just please don't let that impact us. And in terms of termination era policies, let me just frame one superficially innocuous concept that scares the heck out of anybody who's a student of history in Indian law, and that is the concept of opt-in. Again, I know PL 280 is a bad word, but Public Law 280, within its own framework, allows for transfer of jurisdiction, sharing of jurisdiction, compacting if necessary. I would suggest reporters look at Section 1326 of Public Law 280 to look at a mechanism for seeking, collaborative jurisdiction. The problem with having this opt-in solution in various states, and Public Law 280 was applied to California, to Alaska, to Michigan, to Wisconsin, and elsewhere, is that what is optional oftentimes becomes mandatory. Now, having served in the federal system myself, I understand this deeply. When the federal government has limited resources, it has to prioritize. And if the option is just to give authority to the state, there's never the incentive for the federal government to uphold its responsibilities to support tribal capacity and, frankly, fund U.S. attorneys' offices to do their jobs. So over time, resources are squeezed out. This is the lesson from history. We've seen this over the last 50, 60 years. Before the PL 280, let's not call it PL 280. The precursor for the termination policies was the Kansas Act. Same idea. Over time, squeezes out resources. So if any nation, and we've got no issues with any nation, to us, we don't have a conflict with any other single nation, but we are committed to building into every aspect of our sovereignty that has been affirmed to protect tribal members and non-tribal members alike. And we're also committed to holding the US government's feet to its fire to support the capacity building within the federal system. We said that directly to Attorney General Barr when we met with him, when our leadership met with him. And frankly, he was responsive. Why? Because that's the law. The law is when the United States has jurisdiction over certain crimes, as they do on Creek Nation's reservation now, they have a responsibility to go after bad guys. And Creek Nation is there ready to stand with them each step of the way. Our focus should be on capacity building, and that's where we're at with Creek Nation. But we don't have an issue with anybody else that seeks tribe-specific legislation. And frankly, we'll be the first in line to support that.
I think this back and forth actually illustrates some of the complexities. It's hard for folks who work in this area not to go into the weeds. Indian law, more than any other aspect of law in the United States, is informed by history. Not just emotionally, but substantively. But let me end on a note of agreement. I totally agree with Jonodev. There is complete unanimity. There should be no federal legislation that rolls back McGirt. No one's advocating for that. But each tribe is also dealing with very real practical policy issues. And there are divisions within, going back to your question, there are divisions kind of within tribes on these issues. It's funny, the few times I've spoken publicly on McGirt now, I always work in the comment that there's going to be some really interesting conversations we can have like 5 years from now And part of that is because we're in the middle of it. One of the things, and it's hard, the media has not always been a friend to Indian country. And that's not just because of representation, but it's because the media tends to represent majoritarian viewpoints. And even when it represents minority viewpoints, it's still within that majoritarian context. And going back to my earlier point about, tribes predate the United States, and all of federal Indian law really is an arm wrestling between the federal and the state governments, with tribes too often left as bystanders on that. The media has that same problem. So there are a lot of intense discussions going on within tribal polities that need to occur, and they need to occur within a tribal context. I used to serve as counsel to Taos Pueblo, a very traditional tribe, northern New Mexico. Folks have been living on that same piece of real estate for well over 1,000 years. And the level of privacy and leaving non-Taos folks out of the discussion was hardwired into how the tribe made decisions. So for folks outside the fence line, they never understood. They didn't know what was going on. But that's how the tribe survived and stayed together. And that's hardwired into a lot of tribal communities. Here in Oklahoma, because of the histories and the high level of integration between tribal and non-tribal communities, tribes may be more strategic about it, but they're still working hard to protect those internal discussions. And that I think is an interesting thing for media to wrestle with. Y'all are used to, I think, like Freedom of Information Act or Open Meetings Act and all the rest of that. Those are state and federal law mechanisms. The tribes need the level of privacy to go through these processes and come up with the how they want to go on these issues going forward. And that can sometimes create some tension between you all who are trying to figure out the story and the rest of us who are having some pretty intense conversations often, kind of behind the curtain on these things. But more power to you.
So I want to kind of, like, Mike Ray has patiently waited for some answers to his questions, and he brings up the topic of tribal courts experiencing an increase in case filing since McGirt, and do the tribes have sufficient funding and resources to handle those? I've personally been covering this topic for the Muskogee Creek Nation, and we've interviewed judges, and they're talking about, and this is even one of the questions I had outlined earlier, is about data and stats as it relates to this post-McGirt ruling area, because we see the sky is falling again. All these cases are coming, and what are we going to do? We also need to be reporting on the fact that the Muscogee Creek Nation, for example, has invested millions into its justice system. There is massive expansion going on there. The judge who went on record with us, he talked about, yes, there are cases coming on, and there are more than we've seen in ever. However, what did the state of Oklahoma do leading up to this SCOTUS decision that led to this massive influx of cases that are flooding the tribal court systems? Has anyone looked at it from that perspective, and has anyone reported it from that perspective? Because I've seen instances after digging into these county and district courts where they were holding many cases waiting for SCOTUS to make its decision, and then those automatically get filed over to the tribal courts. And that means that tribal courts need to have resources. And we've seen that in some cases they do, some cases they're struggling, or some cases they're just onboarding the manpower and personnel to get this job done, which they haven't been able to do for 100 years because of policy and oversight and overreach of authority. So those are some real interesting context. I've got about 3 or 4 minutes. Who wants to just put us out with the last word on that?
Just really quickly, Creek Nation just authorized $2.1 million for our justice system and an extra $1.2 million for our related civil services, child welfare, social workers. So we're adding, and as our briefs point out, we had 40 plus intergovernmental agreements in the lead up to McGirt. We're well past 60, on our way to 80. The data collection is going to be part of our ongoing work of our commission. Our commission is looking at internal governance issues, but also looking externally at ways to improve dialogue and communication with governmental partners. So, over $3 million investment of critical tribal funds is no small matter. But again, false narratives. What has Oklahoma done to deal? I mean, what's been their role? The fact of the matter is the population in eastern Oklahoma and within Creek Nation is the same. You have the same number of bad actors as before, committing the same number of crimes. Crime hasn't gone up. What has happened with this influx of committed resources from Creek Nation, as well as the U.S. Attorney's Office, is that you have more prosecutors, judges, public defenders, social workers, investigators, adding to the already existing framework, going after bad guys that never existed before. This is good news for the people of Oklahoma, bad news for the bad guys. And so one final point, I'd just like to end on this. I mean, back to these narratives. To be sure, there are transition matters that are to be addressed. That's why we have a commission. That's why we're looking at how we work through all of these. And Creek Nation can't do it alone, and our partners have been pretty good about it. But these are transition matters in the wake of a beautiful case that presents opportunity for everyone. If in the wake of the Brown versus Board of Education decision, people had said, you know what, this is hard. People aren't happy that schools are getting integrated. Can we get a legislative fix to address this? We would have never seen the progress in America that we've had today. So my last request to the journalists on the line is that if anybody explores any aspect of this, legislation, anything related to this doesn't have to be framed as a McGirt solution. Nothing should be discussed in terms of McGirt being a problem to be fixed. These are transition issues in the wake of a historic decision. Nobody talked about a Brown versus Board of Education solution. We need to put McGirt and the McGirt decision into a place in the public consciousness similar to Brown versus Board of Education. That's how historic it is. And we're all in this together. We can do this. We just don't need to water down this case because of short-term challenges. Mado.
Go ahead. Like, make it
all right,
super snappy.
Super snappy. The data doesn't exist. We're creating it now. And part of the reason, because the criminal justice system here in Oklahoma didn't track whether or not someone was a native when they were charged, or whether their victim was a native, or where the crime necessarily, there's no easy way to do it. Jonadev's right, there's no new crime, but we're applying a new set of rules. And there's a lot of logistical work. When looking at a Chickasaw Nation, we've deconstructed the state budget to figure out what the state spends on criminal justice within our reservation. And then we look at what we're spending. We look at our rates of prosecution with our existing system and figure out, okay, what are we set up to handle? What is the state handling in the same area? And we're trying to kind of engineer around that. So we're creating a new data set on this that doesn't exist. Last comment. Thank you all. It's been an honor to be here today. So thank you very much for including me.
I want to thank you guys for making it so easy to moderate. That not many lawyers in the world will just let the reporter in and just let them tell them what to do. So I appreciate your cooperation and all your insights. I'm apologizing to all the questions I couldn't get to in time, and I'm going to pitch it over to Sterling to see us out. These guys are great resources. Call them up and hit them up if you have specific questions for them. I'm sure they'd be great records for you.
And I'll say, Mado, to all three of you, that was just excellent. So thank you again, Mado, to everyone for joining us today. Recording of this webinar will be available at okspj.com. It should be immediately available on the Muskogee Media YouTube page through our live stream there today. We'll be joined here in just a short while at 12 p.m. for our second coverage webinar by two more distinguished tribal law professionals, Sarah Deere and Lindsay Robertson. On behalf of OKSPJ, our partners at Muscogee Media, Mado again for joining us, and my special gratitude again to our panelists for sharing their expertise. I hope to see some of you back again for our second session.
Mado.
Mado.